they kidnapped me from a car with my son.
Is from 2002, allegedly the murder, the attempted murder, and the injury to the child. Is that correct?
Yes.
Where have you been since 2002?
I was in Mexico.
All right, so you're asking for a bond reduction?
Yes, Judge, we had filed back in November, and I think that originally it was going to go to the other court, but now that we're here, Your Honor's been nice enough to consider it today, so we're asking the court to consider it today.
All right, are you ready to proceed?
Sure.
All right, court is calling 2002?
Yes.
Yes, judges.
All right, court is calling 2002 CR 8385 and 2002 CR 8384 and 2002 CR 8386, State versus Jose Mejia. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Charles Bunk for Mr. Mejia.
All right. And are you Mr. Mejia? And how long has your client been in custody?
Since May, he's been here since May the 9th of 2024.
All right. So,
He spent a little time in another county before he was brought here.
all right. So the defense has filed motions to reduce bond in each of its cause numbers. State, did you have a chance to review the motion to reduce bond?
I've spoken with Mr. Buck about it, but I have not looked at them. Judge, I imagine that they're just asking for a reduction.
All right. Were you all able to confer and see if you could reach agreement?
Judge, no, we're not in agreement.
But we confirmed we were not able to reach an agreement.
All right. So, and the cause number ending 84, the bond is currently set at $10,000.
We'll waive our request in 8-4 just to expedite the process.
Okay. Any objection to the waiver?
Right.
And the cause number ending in 85, the bond is set at $100,000. And the cause number ending in 86, the bond is set at $250,000. In 85, he's charged with attempted murder. And in 86, he's charged with murder. All right. Defense, it's your motion.
I'll call my client for the purposes of this hearing.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you're going to need to speak up so I can hear
Yes, ma'am.
and so that the court reporter can hear. You can lower your hand. State your name for the record.
Jose Mejia.
All right, defense.
Mr. Mejia, you're the same Jose Mejia that's charged in those two indictments. Is that correct?
Yes.
And you have been here in the Bexar County Jail since May the 9th of 2024. Is that correct?
Yes.
And on these two bonds, the first bond for the attempted murder is set at $100,000, correct?
Yeah.
And the second bond is set for the murder offense is set at $250,000, correct? Now, I know you have family present in the courtroom. Am I correct?
Yes, sir.
And can you tell the court which members of your family are present today?
It's my mom, my aunt, and my brother-in-law.
Okay. And if those members of your family attempted to raise the funds necessary to make the bonds that are set at the current amount, have they tried to make your bond?
They tried, but it's like,
Have they been able to?
no, they haven't. My mom don't work, she gets, then she has my niece, she's taking care of my niece.
Okay. Now, you yourself, sir, do you have the money yourself to make these bonds?
No,
Okay. Do you own any bank accounts?
no,
Do you own any automobiles?
no,
Do you own any property?
no.
Now, you understand the court, if she considers reducing your bonds, she could put you on devices such as the GPS monitor. Do you understand that?
Yeah, they told me.
Okay. And you certainly would be willing to comply with any conditions of bond she would give you, correct?
Yeah, in the condition.
And would you live, or if you were released on a reduced bond, where would you be planning on living?
With my mom.
With your mother. Does she live here in San Antonio?
In San Antonio.
Okay. For the purposes of this hearing, Judge, that's all I have.
All right, just a moment.
I'm sorry.
I think there's no paper in the printer because I only got 12. All right.
That's all the questions I have for the purposes of this hearing, Judge.
All right. Any questions, State?
Yes, Your Honor. Mr. Mejia, this case is from 2002, allegedly the murder, the attempted murder, and the injury to the child. Is that correct?
Yes.
Where have you been since 2002?
Yeah, I was in Mexico. I got a wife and a kid over there.
And you had a wife and a kid there previous to 2003,
Yeah, no, after,
after 2002.
yeah,
So from 2002 to the present, other than the time that you've been spent here in Bear County or in the other
Yeah.
county, you've been in Mexico for the last roughly 22 years.
yeah, years ago, doing working and having my family.
So you have a family and
Oh, I had a job. I had a
down
job.
in Mexico.
Yeah.
Okay. No further questions, John.
All right, any other questions?
Now, Mr. Mejia, you didn't know that you had these warrants to do until you were arrested, correct?
Yeah, I turned myself in, like,
Right. Once you found
yeah,
out.
because they were there.
Okay, that's all I have, Judge.
Yeah, just
Yes.
one other question. You said you turned yourself in Mexico?
Yeah, I told them I was American because they wanted to lock me up. They kidnapped me from a car with my son. They took me away from a taxi car.
And you're aware who kidnapped you from?
The cops.
The cops,
Yeah,
the Mexican.
yeah.
And then they turned you over to.
No, they didn't turn me in. I told them I was American. They didn't turn me in. I volunteered to.
What, are you aware of why they picked you up from that vehicle?
No, they never told me nothing. They never told my mom nothing. They never told my wife nothing. They just got me and left my son in the taxi.
You're not aware if they are aware that you had warrants out for this murder and attempted murder and injured your child?
No, because if they knew, I had a job and everything. They never arrested me. I've been arrested over there, and they never sent me over here. You know what I mean?
I guess my other question is, you're not aware of a task force that was formed at a recent time in the last year that was gaining people that had, or detaining people in Mexico that had warrants out for attempted murder, but the American side and the Mexican officials
I
have
didn't know none of that.
not aware of that.
No, I wasn't aware.
Thank you. No further question.
All right, any further questions?
That's all I have, Judge.
All right. The court will hear argument, and just off the record for a moment. Edelman? All right, thank you so much. All right, we're back on the record. Yes, I'll hear argument.
Just on behalf of Mr. Mejia, Judge, we're asking the court to consider he's testified he does not have the money available to make the bonds. We're asking the court to consider the reduction of the bond, the we're asking the court to reduce that $250,000 bond to a bond to consider reduction in the amount of $125,000. The $100,000 bond, we're asking the court to consider reducing the amount of $50,000. We're certainly understanding the court will place Mr. Mejia on GPS full house arrest, and we're certainly okay with that. He has a residence here in San Antonio to live with his mother, who is present in the courtroom. He's been present at every setting. The monitor gives the court the guarantee that he will continue to come to court. As he testified, he did not know. Yes, he was in Mexico, but that's not because he did not have these charges and flee the country. It's not a situation where he was on bond and left. That would put the court in a completely different perspective, I believe. So having no evidence that he knew of the charges before he left, I certainly think the court could consider this reduction as a reasonable request. He has been in jail since May 9th of 2024. We don't think the request is unreasonable. We're asking the court to consider the reductions and grants the defense request for bond reductions in 2002, 8385 and 2002, 8386.
Judge Six's position is, for one, that he was aware of the murder, attempted murder, and injury of their child that happened. That's like it's gone to Mexico and it's been there for the last 2 years. So when that argument is a likeness, and also the actual charges, the several charges, the state would be in a position that it's safe to give the community for the leader of the.
All right. In each motion, the court is going to deny your application for reduction. The court will include full GPS. If released, waive all fees as it relates to GPS. And counsel, if he is released and there's an issue, because sometimes there's an issue where GPS thinks there should be a payment, just let the court know and I'll make sure that's done.
Yes, Judge.
All right.
Do we need to address the next setting for the court
Yes.
while we're here?
All right. So with regards to each of these cases, counsel, do you know if you have discovery?
Yes, Mr. Garahan has been able to get the discovery uploaded through the various formats that were antiquated at the time, or antiquated now, present at the time. I believe I have everything that they have.
All right. And so what I will do, State, were you able to tender an offer or no?
No, not today, Your Honor. Mr. Buck asked for an offer today, but I was not prepared to make an offer today.
All right. So what I'll do is I will reset this so the state can tender an offer. What is a good date for you, counsel?
What time frame are you looking at, Judge?
I'm thinking in April.
Okay. Sometime end of April, somewhere in there?
Well, it would have to be April the 28th.
April the 28th, okay.
As you know, my mom's birthday is before that.
Yes, so the 28th is good, Judge.
All right, Ms. Ferguson.
Is that Fiesta?
Oh,
Yes,
Fiesta.
that is Fiesta.
I don't want to ruin their fiesta.
Understood.
So I can put it May 1st.
That's fine.
All right, Deputy Laura, May 1st, because I understand fiesta is over.
Yes.
In the month, am I right? In the month of May? Oh, look at Raymond shaking his head. Okay, so he just throwing it. Okay.
Yeah.
All right, so we're going to be back then on May 5th,
May 5th.
Cinco de Mayo.
Okay.
All right. Yes, it's for discovery and for the state to tender an offer, but just have an acknowledgement of discovery right on that day. All right. Is there anything else?
No, Judge.
All right. Back in 2019, then on August 5th, a motion to revoke was filed and you were continued. I allowed you to transfer to Mississippi. Then on February 8, 2021, there was a new motion to revoke, which was a new case that you committed because you pled true to it. The court denied it and continued you. Then we come back on May 5th, 2021. There's another motion to revoke, and that's a violation of number 26. The court continued you. 2019 CR 0925W, State of Texas versus Joshua Clark. Showing you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review it with your attorney? Did you understand it? Are you the same Joshua Clark who was placed on deferred adjudication in 2019 CR 0925W for the offense of aggravated assault with a deadly weapon on February 22nd, 2019 for a period of 8 years? Is that you? State?
Your Honor, when we previously approached on this, we were proceeding on a violation of count 2 that on or about the 19th day of September 2022 in Bexar County, Texas. The defendant, Joshua Clark, did then and there test positive for marijuana in violation of condition number 2.
How do you plead to that? True or not true?
Thank you, Your Honor. He's already our last set he played through, and the number 2 that he played to was actually failing to submit.
I apologize, Your Honor, I was reading the wrong violation.
And he's already played through his appeal form's already been. We just came back to the court to take a look at it and decide what the reason.
All right. And so what does he have?
He has the new offense he picked up was an evading arrest when they came to get him. Of course, that's one of the allegations that's been waived and abandoned.
So why are we here?
Because I don't know if the wants to look below there should be argued in my own 3 years. No objections.
No difference.
Okay. All right. I'll hear argument. State.
Your Honor, the underlying case that the defendant was charged for was for ag assault with a deadly weapon. The defendant has since failed to report multiple times to his supervision officer, failed to submit to drug testing, and further was picked up on a new charge, although the state has waived that allegation. Since January 21st of 2022, the defendant has failed to submit 6 times and further tested positive and tested for a diluted sample. The defendant has been given a chance to comply with the conditions that he agreed to when he was first granted to the deferred adjudication. And along with these allegations, the defendant has chosen to
stray from following those conditions and has shown that he is not suitable for deferred adjudication. So we're asking you to revoke the defendant's deferred adjudication sentence of the 4 years.
All right, defense.
Your Honor, there's been some adjustment with Mr. Clark, of course, when he was out, he was working. He also had gotten himself in the field. He had personal training in an effort to mitigate his track as he was trying to get his community service hours, and we told him that was something for him to do, and making it good for him. In terms of without getting into the specific facts of the abatement, because again, it has been waived, there was some question as to whether the first car that he was seen wasn't unlocked. I think that's just the best way to say it. The neighborhood that he lives in, not the best of neighborhoods, but he had been following the court's instructions in terms of staying away.
Just 1 second. All right, everybody in the box, you need to whisper. I'm being patient. I have patience in my pocket, but I have an issue understanding why is it that there is no chatter when we're off the record, but the minute we go on the record, then everybody moves with the purpose to start chattering and approaching the court coordinator. So if we cannot whisper, then we cannot talk in the box. You may continue.
In terms of the job that he had, one of the issues with the testing, what the court knows that it's random testing. So there's few times where he'd have to leave his job to go down there. It's been explained to him, and he fully understands how moving forward, that's just not going to work. That the fact that he's at work, and he feels like he can't leave. He wants to keep a job, where he might still want getting one. But it's been explained to him, and he understands now that if he has to go test, he has to go test, and he may have to just find a different job that's going to be more compatible with those applications of the probation. In terms of testing for his been for a while, he would be able to test, but he would be able to pass a drug test today. He's in school, he is working, he's putting forth what I believe is the best effort that he knows to put forward, but he knows to do a better job. And so we would ask the court to consider continuing him on his deferred adjudication, or in the alternative, if the court is inclined to convict him, to continue him on probation with the conviction.
All right, so Mr. Clark, here's the issue. The issue is the court has given you chance after chance after chance. You were placed on deferred adjudication February 22nd, 2019. Then on August 5th, a motion to revoke was filed and you were continued. I allowed you to transfer to Mississippi. Then on February 8, 2021, there was a new motion to revoke, which was a new case that you committed because you pled true to it. The court denied it and continued you. Then we come back on May 5th, 2021. There's another motion to revoke, and that's a violation of number 26. The court continued you, and now we are here. So I don't believe there's anything else that I can do to make you follow the court's condition. I'm going to grant the motion, find you guilty. There's an affirmative finding of deadly weapon. There's to be no contact with Brianna, Bryanna Reed. I don't think there wasn't an affirmative finding of family violence on this. Let me see if all right. And the court will sentence you to 4 years in the prison, and you receive any credit for any time served, $1,500 fine, time and money to run concurrent. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right. You do have a limited right to appeal, and that right is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? All right. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, we can go off the record. How old are you? 31. All right, so you're going to have to change your life. I know sometimes people are sentenced to prison and they think it's the end of the world. And I've never been sentenced to prison, so I can't say, oh, It's easy. It's not easy. I always never thought it was easy. But what I can tell you is you need to take advantage and try to rehabilitate yourself so you won't be back in this situation. Because time is going to pass, whether you're living right or living wrong, and you want to make sure that you're living right so you'll have a chance in life. You understand? All right. Good luck to you.
Joshua Clark was placed on deferred adjudication probation in 2019 after being charged with aggravated assault with a deadly weapon. Instead of following the court's conditions, Clark repeatedly failed to comply with his supervision requirements over several years. He missed multiple drug tests, tested positive for marijuana, and submitted a diluted sample in an attempt to avoid detection. He also picked up a new criminal charge while still on probation. Judge Stephanie Boyd noted that the court had given Clark chance after chance, continuing his probation 3 separate times. After years of repeated violations, Judge Boyd found that Clark was no longer suitable for probation and sentenced him to 4 years in prison along with a $1,500 fine. Clark was 31 years old at the time of sentencing.